You have the payment receipt. You have the email. You have the appointment confirmation, or at least the screenshot showing that you tried to book one. Then AIMA tells you, we cannot find your application. Before you make another emotional phone call, stop. Your first job is to find out what the administration systems actually say about you.
Let's call the applicant Marta. She paid on March 4th, uploaded her passport and supporting documents on March 12th, and saved the confirmation email. 4 months later, one channel said the application was pending. Another said no application existed. Then someone asked for documents Marta had already sent. She was not missing evidence. She was missing a reliable record of what the system had done with it.
Welcome to Portugal Rights Rebel, episode number. I'm Elena Vargas. Today, we tackle one of the most common nightmares expats face in Portugal and show you exactly how to fight back, legally and effectively. We are going to use the GDPR as an evidence tool, not a magic wand, not an immigration appeal, an evidence tool. A GDPR access request can help you learn what personal data connected to you is being processed, what references or status entries may exist, and whether important facts appear to be wrong or missing. It does not automatically renew your resident status. It does not force AIMA to approve an application. It does not stop an appeal deadline, and it may not release every internal note or document. Keep your immigration remedies and deadlines on a separate track. And I can hear the question, if AIMA is holding the wrong record, why not simply demand the entire file? Because access to your personal data is not automatically access to every administrative document, another person's information, or material covered by a lawful restriction. Ask precisely for data concerning you. If you need the broader administrative file or an urgent immigration remedy, a qualified Portuguese lawyer can identify the correct route. The legal foundation begins with GDPR Article 15, which generally gives you a right to request access to personal data concerning you and information about how that data is processed. That can include the purposes of processing, categories of data, recipients, retention information, and, where applicable, a copy of the personal data. Article 12 concerns transparent communication and the handling of rights requests. Article 16 gives you a route to ask for inaccurate data to be corrected or incomplete data to be completed.
Portugal's Law 58-2019 operates alongside the GDPR, but addresses privacy notices, identity requirements, and procedures can change. Before you send anything, check the current privacy information for the organization handling your data. Confirm whether it is the controller, which official channel accepts the request, and what identity verification it requires. Do not trust an old template or an address copied from a social media comment.
Build the request around 3 things: who you are, which file you mean, and which records you want. Give your name as used in the application, the reference number if you have one, and any identity details required by the official process. Give the date range and the type of immigration procedure. Then name the categories: application and upload metadata, appointment history, payment references, correspondence addressed to you, notices, status entries, and recorded decision information connected to your file. A focused sentence could sound like this: please provide access to personal data concerning me processed in connection with my residence application and related appointments between these dates, including application identifiers, submission records, document receipt metadata, correspondence, status entries, and decision information, together with the processing information required under Article 15. Then stop. You do not need to include your entire life story. Precision reduces confusion. If your case involves a spouse, child, employer, investor, or representative, be careful. Request your own data. Redact unnecessary third-party information from attachments. Do not casually ask for another person's immigration file because it is connected to yours. Separate authorization or separate requests may be appropriate, and a lawyer can help you decide. Before you press send, build the timeline. Payment, upload,
appointment, email, response. Now label each item: official receipt, portal screenshot, email header, bank record, or memory. That last distinction matters. Memory can be useful, but it is not the same as delivery proof. Save the request exactly as submitted, keep the sent email and full headers where possible, and store every receipt or confirmation.
Use simple file names, such as payment receipt, followed by the date, or AIMA request sent, followed by the date. Redact what does not need to be shared, and store sensitive materials securely. A searchable evidence bundle is much easier to review than a folder called Portugal Documents Final 2. The computer may forgive that folder. A deadline will not.
Track the response period under the current instructions. The GDPR commonly refers to responding without undue delay and, in principle, within 1 month, with possible extensions in some circumstances. That is not a promise that every record will arrive in one neat bundle. The authority may request clarification, verify your identity, or explain that some material is restricted. Write down the date your request was received and set a reminder. Do not rely on memory.
When the response arrives, do not read it once and close the email. Put it beside your evidence. What date do they have? What date do you have? Which reference appears in one record but not the other? Make 4 columns: what the authority says, what your documents show, what appears missing or inaccurate, and what question remains.
If a receipt shows a document was submitted, but the response treats it as absent, flag the conflict. If the authority says no data exists, ask whether the search covered the relevant systems, reference numbers, and date range. Do it calmly and specifically. Not every absence proves misconduct. A record may have been retained under another reference, removed under a retention rule, or withheld under a lawful limitation. Separate a factual error from missing context, lawful withholding, and a record that genuinely cannot be located.
If you find inaccurate personal data, make a focused correction request under Article 16. Identify the exact entry, explain why it is wrong or incomplete, and attach the smallest useful proof. A simple table can help: existing entry, requested correction, supporting document, and consequence of leaving the error unchanged. You are asking for a factual correction, not demanding that the authority adopt your preferred legal argument.
If there is no response, or the response is incomplete or refused, preserve the original request and delivery proof. Check the current instructions for the relevant controller and for Portugal's Data Protection Authority, CNPD. A CNPD complaint should focus on the data rights problem, access, correction, transparency, or the way your request was handled. It is not a shortcut to residence approval. Keep the immigration problem separate. Delay, refusal, an expiring status, family separation, or an urgent travel issue may require a different complaint, administrative remedy, or court action. A GDPR request does not pause those deadlines. If your status or court rights are at risk, speak with a qualified Portuguese immigration lawyer before waiting for the data response. A lawyer may compare the data response with the administrative file, identify contradictions, prepare a focused complaint, or assess whether documented delay and harm could support a compensation theory. But compensation is not automatic. The analysis may involve legal grounds, conduct, causation, actual damage, evidence, and possible defenses. An incorrect database entry can matter without guaranteeing a payout. Think back to Marta. She kept the payment receipt, the upload confirmation, portal screenshots, and a dated chronology. When the response contained the wrong date and omitted a submission reference, her lawyer could identify the disputed points and prepare a focused correction request. Another applicant relied mostly on phone calls and verbal assurances. That person had the same suspicion, but no dated proof. Every next step began by trying to reconstruct the past. That is the larger lesson. Bureaucracy is harder to challenge when every conversation disappears into the air. A written request creates a date. A receipt creates a delivery fact. A response creates something that can be checked. None of this guarantees success, but it replaces helpless repetition with an accountable record. The system is slow. Your preparation shouldn't be. Here is your action for today. Find the current privacy notice for the authority handling your data. Write down your application reference and date range. Draft one focused access request. Remove unnecessary information about other people. Verify the official identity and submission instructions, and save proof of delivery. If an immigration, appeal, or court deadline is at risk, consult a qualified Portuguese lawyer before relying on the data response.
Check current guidance from AIMA, CNPD, and other official sources because procedures can change. This episode is general information, not individualized legal advice. Use the data trail to understand and correct personal data problems while keeping every immigration deadline separate.
If this episode helped you turn a confusing file into a clear evidence plan, subscribe to Portugal Rights Rebel and share it with someone facing an unexplained delay. Send it to your lawyer before your next consultation and watch for the next practical rights defense checklist. Turn bureaucracy into accountability. Your rights don't disappear at the border. Knowledge is your best defense. Document everything, act lawfully, and protect your future. Always consult a qualified Portuguese lawyer for your specific case.